Our next speaker is Jackie Power. That one was a little easier for me. Jackie Power is Director of Tax and Estate Planning at Mackenzie Investments. She has been with Mackenzie Investments for over 20 years. Jackie works with financial advisors to help create tax and estate planning strategies for their clients. In addition to meeting one-on-one with advisors and investors, Jackie puts together informative presentations to help clients fully understand this important component of their financial plan. Jackie has a Bachelor of Arts degree in economics from the University of Western Ontario. Please welcome Jackie Power.
Hi everyone, thank you so much for listening to me tonight. I'm really happy to be here to speak with all of you with respect to estate planning. This is something that's extremely important to all of us, and there are some steps that I'll take you through tonight that will help you understand the things that you need to consider in order to be able to put the best possible plan together for you. So this is my standard disclaimer. I am not here to replace any advice that you might be receiving from lawyers, accountants, any sort of tax professionals. I'm really here today just to provide you with information that will help you in your discussions with those individuals. So let's get to it. So the first step is working with your advisor to set realistic goals. So this is where you're working with the Langlois team, where you're explaining, what do you want to do in your retirement? Is travel important to you? Do you want to purchase a property? Are you interested in maybe moving across the country? Whatever your goals are, you need to make sure that you're communicating that to your team, because they're not able to put you into the right investments and find a way to help you achieve those goals if they don't even know what your goals are. So that's the first step, and that's one area that I'll be focusing on a lot tonight. The next is to consider the tools to fit your situation. So when I'm talking about tools, we're talking about wills, powers of attorney, that sort of thing. Who do you want to really be helping you with your plan and putting this through over time? The next is to choose the people to speak with for you. Who do you want your executor to be? Who do you want your power of attorney to be? And these are decisions that are difficult to make because these individuals have a lot of control. Essentially, your powers of attorney for property are able to do everything that you're able to do, except they cannot write a will and they cannot make beneficiary designations. But everything else they can do the way that you would be able to do it. So that's a lot of power that you're putting into someone's hands. And you want to make sure that you're choosing the right person for that role. And then the other one is communication. This is something that you're going to hear from me a lot tonight. Communication is key. If you're looking to ensure that there aren't problems with your plan after you've passed, you need to make sure that your family members understand why you made the decisions that you made. And if you don't have that communication, that's when problems can occur within the family, and your wishes may not end up going forward the way that you had originally hoped they would. And then the last area that I'll talk about is keeping your plan up to date. Anytime that you have any sort of a change within your particular situation, make sure that you are communicating that to your team of financial advisors. Make sure that they're aware of the change. It could be very small as far as you're concerned, but this could actually have a large effect on your overall plan. So you need to make sure that that is communicated to the team. So as far as setting realistic goals, I think a lot of us are looking to minimize tax. And there are lots of different ways that this can be done. One way is if you have a spouse, generally you want your spouse to inherit your assets because your spouse is able to inherit those on a tax-deferred basis. And it's only when the second spouse passes away that at that point there would be a tax liability. So it's generally advantageous to have them inherit. Also, think about who do you want your survivors to be? Who do you want to be supporting after you've passed away? It might be family members, it might be friends. There might be a neighbor down the street who's been extremely helpful to you over the years that you want to be able to help. So these are decisions that you need to make. And anybody that you want to include in your plan, you need to make sure that that's included in your will. If it's not in your will, then those individuals will not be able to inherit and you won't be able to provide for them the way that you had hoped you would. Now, if you happen to be a business owner, it is extremely important to make sure that you're planning as far as the business is concerned as well. So if it's a corporation, very important to make sure that there's a shareholder agreement in place that dictates what happens in the event that somebody passes away, one of the shareholders, or that somebody becomes disabled. Is there insurance money in the event of someone's death that pays out to the corporation that can be used to buy out the surviving spouse? This can all be included in a shareholder agreement, and it really is essentially a roadmap that allows the individuals who are left behind to be able to go forward with the plan that you had originally wanted. And you want to make sure that you're putting these shareholder agreements in place before somebody becomes ill, before somebody passes away, so that that roadmap is there in the event that something happens. Also, you want to make sure that you identify who do you want to be the guardian of any minor children that you may have. This is an area where I feel that a lot of people are not going forward with their wills because they don't know who they want as the guardian of their children. And as somebody who does this for a living, you would think that I would be smarter, but my husband and I fell into this exact situation. We'd chosen somebody that we wanted as far as our guardians are concerned, but as we watched them and watched how they were raising their children, we realized that's not the way we want our children to be raised. And as a result, we needed to make a decision. But then it's a matter of going through and trying to decide who is good enough, if you will, to raise our kids. And it was a really hard decision on our part. We finally ended up finding the perfect person. But I'll be honest, there was probably a year that we didn't have a will. And I can tell you that was the most stressful the year of our lives. If my husband and I were ever in a car together, we were terrified that we would get in a car accident and that the other people would think they were getting our kids. So it's really stressful, but this is why I think a lot of people don't go forward and put the will together. So I know it's a difficult decision, and I know that there's a lot of thought that goes through into this, but please don't make the mistake that my husband and I made. Please choose somebody and make sure you're putting that will together, because as I go through this presentation, you'll see if you don't have a will, you're losing control over how your estate is distributed, and you don't want the province to be deciding how your estate is being distributed. So when we're talking about transferring assets tax efficiently, insurance is extremely important. This is a part of your plan that is one of the biggest parts, and this, I'm sure your team has talked to you about insurance, I'm sure, but I want you to understand why it's so important. There is a massive amount of tax that your estate is going to pay when the second spouse passes away. If you have insurance money that's paying into the estate, that can cover that insurance bill, and that can be, that tax bill, and that can be very helpful to your estate. Some people also use insurance as a way of equalizing an estate. So if one individual is receiving property, maybe they want another individual to receive insurance money. But insurance is definitely something that if you haven't already talked to your team about, make sure that you talk to them about it. They are extremely well versed as far as insurance is concerned, and would be more than happy to talk to you and help you understand how that can fit in to your particular plan. Another thing to think about are those registered accounts. As I mentioned, if you have a spouse, generally you want your spouse to inherit those accounts because they can inherit those on a tax-deferred basis. Now, you may not be aware, but registered accounts, when you pass away, are considered to be sold on the day that you pass away. So essentially, depending on what the size of your registered account is, you could be subject to tax of 53.53%. So it's a massive amount of tax that applies to those registered assets. And again, that goes back to the fact that that's why insurance is important, because there is that massive tax hit that's going to happen at the time that you pass away. Now, shortly, I'll talk a little bit more about registered accounts and help you understand some more things to think about with respect to that. Something else to consider is gifting. What a lot of people want to do is they want to gift prior to death, because then that asset doesn't form part of your estate when you pass away. And in that situation, it wouldn't be subject to probate. And that's something else that I'll be discussing shortly. My concern is you don't want to gift too much, Because you might think that you're only going to live X amount of years, but none of us have that crystal ball knowing exactly how long we're going to survive. So you want to make sure that you don't give too much and not be able to live the life that you want to live, be able to do the things that you want to be able to do. Another thing to consider are joint accounts. So if an account is joint with right of survivorship, essentially what happens is that the surviving joint account holder will inherit that asset, and there will be no probate that applies to that asset. Now, there's still capital gains tax on half of the account of the deceased individual, but there would be no probate that would apply. So a lot of people love the idea of doing this because of the fact that you would be saving on those probate taxes. One thing that I caution is that you could end up costing yourself more by trying to avoid probate than what your estate would be paying as far as probate is concerned. So I'll go into give you a little example. So essentially, if you put your adult child on as a joint holder of your account, at the time that you put that adult child on the account, you would deem dispose half of the account. So essentially, you're paying tax on half of the account. And now that adult child owns half of your account. So that's fantastic from a probate standpoint because now it'll just flip to them, no probate will apply. But if that child has creditors, that's the child's asset, half of that account. So their creditors can seize the child's half of the account. If the child happens to go through a marriage breakdown, this is considered family property when that equalization calculation is being done. So that's why I was saying when you're trying to think about ways to avoid probate, you could cost yourself more than what that probate fee would be. So when you're making decisions, you need to make decisions as to what's best for you, not simply trying to avoid that probate. So as far as those registered accounts are concerned, your spouse can be on your RIF account, on your Registered Retirement Income Fund, as a successor holder. So essentially what would happen in that situation is when you pass away, your spouse would inherit that account. So whatever payments are currently coming out of that RIF account, those will continue to come out to the surviving spouse. So that's fantastic if you're happy with the way that the RIF payments are coming out right now. If you're looking for more flexibility, then you want your spouse to be the beneficiary of your RIF account, because essentially what happens then is that they can roll that account tax deferred into their own RIF, or if they aren't of that age as of yet, they can roll it into their RSP on a tax deferred basis. And then when they're ready to start making withdrawals from the RIF, they can choose to have it based on their age, rather than have it stuck with what the original payments were. So if you're looking for flexibility, generally you would want your spouse to be the beneficiary rather than the successor on the RIF. Now, one area that's really important to be aware of that a lot of people aren't aware of are Registered Education Savings Plans, or RESPs. So a lot of individuals believe that the RESP it's owned by the beneficiary of that account. That is not the case. The RESP is owned by the subscriber, by the individual who set up that account. So if there's just one subscriber on the account and that individual passes away, it's really important to make sure that they've given direction in their will as to what they would like to have done with that account. And the reason being is that if there's no direction given, the executor has full right to collapse that account and distribute the assets in that account to the beneficiary of the deceased's estate. And then the beneficiary of the RESP would lose that money for university. And we have seen this happen time and time again, where the executor doesn't have children who are beneficiaries of the RESP account and have ended up collapsing it because there was no direction that was given as to what should happen with that account. So that's why it's so important, if you are the sole subscriber on an RESP, to make sure that there's some sort of direction as to who you would like the new subscriber of that account to be in your will. Now, the next account type is the tax-free savings account. This is an excellent account that I'll go into a lot more detail about shortly. Essentially with this account, this is one area where you want your spouse to be the successor holder. And the reason is because it's much more tax efficient for them to be successor holder. Essentially, they can inherit the entire account tax-free, and they do not need TFSA contribution room to put that into their own TFSA if they want to do that. So there's much more flexibility if your spouse is the successor rather than being the beneficiary of the account. And I'm very visual, so I'll show you a chart shortly that shows you exactly how that would work and why it's so beneficial. So when we're looking at the tax-free savings account, this has been around since 2009. This is an excellent account type because any growth in the account is tax-free. When you make withdrawals from the account, those are also tax-free. And if you do make withdrawals, you get that TFSA contribution room back January 1st of the following year. So it's a great account if you're looking to maybe save for a down payment on a house, or you want to go on vacation, buy a new boat. Any reason that you might want to save money, this is an excellent account type to save money. Right now, the contribution limit is $5,500. If you've been eligible for a TFSA since 2009 and you've never made a TFSA contribution, you have $57,500 available to you in TFSA contribution room. Where we find a lot of people are funding their TFSAs is if they receive an inheritance, because you would receive that inheritance after the estate has paid that tax. So you have tax-free money, and then you can put that into a tax-free savings account. So that inheritance would just continue to grow tax-free over time and really allow you to sort of develop quite a nice nest egg of tax-free money that you can use as you see fit. So I'd mentioned that I was going to show you the visual of why you want your spouse to be the successor holder. So you can see the middle line that has the green and the blue. If your spouse is successor holder, they inherit the entire account tax-free, and they do not need TFSA contribution room to put that money into their TFSA. If your spouse is the beneficiary, they can still inherit the account up until date of death tax-free, but any growth from the date of death until the date they receive it would be taxable to them. And if they want to put that in their TFSA, they do need TFSA contribution room for that. So if you do have a spouse, I highly recommend that you ensure that your spouse is set up as a successor holder. So let's switch gears a bit and talk about probate. So probate is essentially, it's done on a province-by-province basis. And essentially what it's doing is it's giving the executor the authority to be able to distribute and settle the estate. Essentially, if somebody does not have a will, then you need to go through the probate process in order to be able to get somebody appointed as the executor on that particular estate. There are fees that are involved in probate, and I will talk about those shortly. So essentially, the way that probate works is that any assets that flow through the estate are subject to probate. So that would be any non-registered assets that you may have, whether they're invested in stocks, bonds, mutual funds. All of your non-registered assets would flow through your estate, so would be subject to probate. Same thing with if you have jewelry collections, automobiles, coin collections, art collections, anything like that would be subject to probate. If you happen to have antiques within your home, those would also be included in the probate calculation. Any real estate that you happen to have in Ontario that's not joint with right of survivorship, that would also be subject to probate, less the value of any mortgages that may be on there. So you're not paying probate on those mortgages. So you can see here that what's excluded. And as far as included, if you have registered accounts or life insurance policies that have the estate as the beneficiary, then those would also be included in the probate calculation. So what's excluded, those registered accounts, if you have beneficiary designations on those or on life insurance policies, those will pay directly to the beneficiaries. As a result, they will not form part of the probate calculation. Same thing with any sort of accounts that are joint with right of survivorship that I'd mentioned. Those also will not form part of the probate calculation or those mortgages on the property. So as you can see, probate is not a huge amount. The first $50,000 of an estate is charged 0.5% in probate. Anything over $50,000 is charged 1.5%. So if you're looking at a $2 million estate, you're looking at about $29,500 in probate. So not a huge amount, and that's why I'm saying, you know, when you're making decisions, make decisions for what's best for you, and don't simply try to avoid probate because the amount isn't as large as what some people may think. So there were a lot of changes that happened as far as probate was concerned in 2015. So prior to 2015, it was really simple to get probate for an estate. Essentially what would happen is an application was made to the Superior Court of Justice in Ontario. The executor would say this is what the value of the estate is. They would sign an affidavit to that effect. There were no valuations that were required, and they would pay probate on whatever that amount was. But what the government found was that they were missing out on a lot of probate dollars. Where we feel that this was most prevalent were those cottages in Muskoka. So the executor would say, this cottage is valued at $1 million. 6 months later, they would turn it around and sell it for more than $2 million. And this happened enough times that the government realized that they needed to make some changes. So they definitely made changes. First thing that they did is they changed the administration from the Attorney General to the Ministry of Finance, because they felt the Ministry of Finance would be more likely to be able to collect those probate dollars. The next thing that they did is they now require that an estate information return be created for all assets that are flowing through the estate. Now, you can clump assets. So if there's a jewelry collection, like if there's lots of jewelry, that would be on one estate information return. Coin collections, all on one estate information return. But every group of assets need to have their own estate information return, and this needs to be filed within 90 days from when the probate certificate is issued. So essentially what the estate information return does is it gives information on all of the assets that flow through the estate. If there is fraudulent information, misleading information, the government can essentially fine the executor up to 2 times what the tax payable would have been. And in severe situations, they have the ability to imprison people. So I've heard of no situations as of yet where someone's been imprisoned, but the government does have that in their back pocket should they choose to use it. So the idea behind this is that the government feels that by having this estate information return, it's going to make it a lot easier for them to audit an estate because of the amount of information that they have on all of the assets that are flowing through that estate. So as far as what's included, first and foremost, there's information about the deceased. Then there's information about the executor, and then, as I said, any of those assets that flow through the estate would be included on that form as well. So essentially, this is due within 90 days from when that probate certificate is issued. If the executor is made aware of information about certain assets after that estate information return has been filed, they have 30 days from when they become aware of it to file an estate information return for that particular asset. Now, the government can come back and reassess the estate for up to 4 years if they feel there are no issues with the estate whatsoever. If they feel there was fraudulent or misleading information, at that point they can come back and reassess the estate indefinitely. So it's really important to make sure an executor is keeping records for a relatively long period of time to ensure that if the estate does get audited, that they have the documents to back up that audit. So the next area that I wanted to focus on was consider the tools to fit your situation. So when we're talking about this, we're talking about wills, trusts, powers of attorney, that sort of thing. If you have any sort of a wish as far as certain things are concerned with respect to your funeral, make sure that you communicate that to your executor. Make sure you communicate that to your family members. If you've prearranged your funeral, even more important to make sure that that's communicated so that your wishes are able to go forward. Same thing if organ donation is something that's important to you. Family has the last say as far as organ donation is concerned. So you want to make sure that your family understands what your wishes are with respect to that. So what I really want to talk about is the will. So the will really is the cornerstone of your estate plan. It's in the will that you're going to indicate who are the beneficiaries of your estate, who are the executors, who's going to be the guardians of those minor children. If you do not have a will in place, at that point you lose control over how your estate is distributed. Essentially, it's then up to the province to decide who gets your assets. Before I got into this role, I just assumed that in the event that I passed away, my husband would inherit my assets. That's not the case at all. So essentially, the way that it works is that my husband would get the first $200,000 of the estate. After that, my minor children get 2/3 of the estate, and my husband gets the remaining 1/3. My husband has no say whatsoever in how the kids' assets are managed, and as soon as they turn 18, they get full access to that money. What I find even scarier is that common law is not recognized for intestacy purposes. So if you're in a common law relationship or you know someone who is, it's even more important to make sure that you have a will so that you can dictate how that estate is going to be distributed and ensure that your common law spouse is able to inherit. And I think a lot of people are not aware that common law is not recognized as far as intestacy is concerned because of the fact that a common law spouse is a spouse in so many other areas of our lives. But this is something that's really important to be aware of. So the next area is to choose the people you want to speak for you. So when I'm talking about this is where I'm talking about who do you want your executor to be? Who do you want your power of attorney to be? And this is a decision it's a huge decision that you need to make, and you need to really think about who has the skills that are needed to be able to settle an estate. And I know a lot of times with parents, you want the children to be equal, and you want the children to, that's how our family is anyways. My mom, it's all about being equal. There's just my brother and I. And with her, she always wants everything to be equal. So my brother's a restaurateur, and this is what I do for a living. So logically, it would make sense that I would be her executor. And I'm happy to say she did choose me as her executor, but her thought process was quite entertaining. So I was on maternity leave at the time that she asked me. And she said, "Jackie, will you be my executor?" And I said, "Of course, Mom, I would be honored to be your executor. Thank you very much." And she said, "The reason I chose you instead of your brother is because you're on maternity leave." And I said, "Oh, really? You're planning to die in the next year?" And she was sort of taken aback by that and sort of surprised, but she got to the right decision. And that's all that I'm saying to you tonight. However you get to the right decision as far as who you want as your executor, you just want to make sure, whatever justification you need to choose the right person, you just want to make sure that you're choosing the right person. Because not everyone has the skills to be somebody's executor. Not everyone has the time to be an executor. It's a huge amount of time that's involved in settling somebody's estate. Now, when you're thinking about somebody, you want as much as possible to find somebody who's local. So if someone's in the same city as you, that would be ideal. Same province would be extremely helpful, but you definitely want them in the same country. And the reason for that is if they're in another country, they need to be bonded in order to be able to settle the estate here in Canada. And that can be time-consuming, that can be costly for them to do that. Also, the estate would have to cover any expenses to fly them from wherever they happen to be, to put them up in a hotel here. So that's why it's so important, if it's at all possible, to find someone local. Now, it's not a requirement. As I said, I'm my mom's executor. My mom lives in BC, and I'll be settling her estate out west, so it's not a requirement. None of our family is out west, and that's why she had to choose someone from Ontario, because my brother and I are both here in Ontario. But these are just a few things to consider when you're making those choices. Now, the next one is to communicate your wishes. Without communication, that's when legal battles start. If people don't understand why you've made the decisions that you've made, then that can cause some issues. So I'm going to give you two personal stories as far as my family's concerned to help you understand where this could be a problem and how we were able to stop it from being an issue. So as I mentioned, my brother's a restaurateur. When he went to open his restaurant, he borrowed a substantial amount of money from my mom and just didn't end up paying her back. So what my mom did is changed her will and said that I get X amount of dollars off the top, and then after that, everything is split evenly between my brother and I. My mom and I had to have a conversation with my brother about this because my mom and I are extremely close to my brother and I are extremely close to my mom. When she passes away, it's not going to be a good situation, and any reason that my brother and I could fight, we likely will. So she wanted to make sure that that wasn't going to be an issue because I guarantee if we had not had this conversation with my brother and explained that I was getting this extra money, he would have said to me, "What did you do to Mom as her executor to get her to give you that extra money?" But when we had the conversation and said, okay, this is the reason why the will is written this way, my brother said, of course, that makes perfect sense. Because we had the conversation when we were all level-headed, when we were all, nobody was sick, nobody was dying, everything was fine. So that's when you want to have these conversations, and that's why it's so important to communicate. Now, the next one is with my mother-in-law's estate, and this goes to fair is not always equal. So that's something to think about when you're putting your plan together as well. So my mother-in-law has a ridiculously complicated estate. So she owns her principal residence with my sister-in-law and brother-in-law and lives there with my two nephews. She owns a cottage up north in Wasaga Beach with her sister, and then she inherited a house in downtown Toronto that she owns with her brother and her sister. So the only good thing, I know, it's insane, eh? So the only good thing with all of this is that her brother and sister don't have any kids. Think of my husband and his sisters as their kids. So they're willing to distribute the assets however they want. So essentially, the sister-in-law who's living with her is going to inherit the house in East Toronto. My other sister-in-law is in her early 30s and just can't get into the Toronto housing market. So she's going to inherit the house in downtown Toronto, and then my husband's going to inherit the cottage in Wasaga Beach. Is this fair? 100%. Is this equal? No. The sister in downtown Toronto is by far winning, and my husband's the one who's sort of getting the short end of the stick. But because there was communication, there's no hard feelings with anybody. My mother-in-law said, like my family and I, my husband and I and our kids, go up to the cottage almost every single weekend. Our kids think it's our cottage, even though we try to explain to them it's not, but they're too young. And so anyway, the cottage is so important to us. So as far as we're concerned, this is 100% fair. But I guarantee if this conversation had not happened, my husband would have wondered, what did I do? How did I upset Mom so much that made her give me such a small inheritance compared to my other two sisters? But when you have that communication, then it really avoids these sorts of issues. And that's why it's so important to make sure that you talk to family about why you're making the decisions that you're making and help them understand where your thought process was. So the last area that I wanted to talk about is just keeping your plan up to date. So anytime that you have any sort of a change in your situation, make sure that your financial advisors are aware of it. Make sure your lawyer's aware of it. If you're working with an accountant, that they're aware of any changes. Because it could be something that you think is very small as far as the change is concerned, and it could really have a dramatic effect on your overall plan. So making sure that they understand what's happened within your life is so important, and will just make your plan going forward so much better. So thank you so much for your time today. I really appreciate being able to be here to speak with all of you, and have a wonderful evening.